one who is the meaning of justice and mercy. Amen.
Well, hello everyone. Thanks for being here. Thanks for inviting me to talk on this issue. And I want to try to give you an overview of how we're in this situation. All right. Yeah, let me just use this one. All right. Thanks. So, you know, you heard the number 36,000 people in solitary confinement from Heather Rice of the National Religious Campaign, and I actually think that significantly underestimates the number of people. It's a little fuzzy, the actual numbers, because the authorities don't keep statistics, probably because it's embarrassing, the number of people, but I think the people that have really looked at it and studied it put the number at more like 80,000 to 100,000 and maybe more right now being held in long-term solitary confinement. And remember, that excludes people that are confined in solitary for short-term disciplinary means. These are people who are confined 23 hours a day to 8 by 10 foot type cells, often with no sunlight, no human contact, food passed through a very narrow window, no reading materials, really just sitting alone with silence all day, every day, without end. The history of solitary confinement in this country, where it has been institutionalized to a degree that no other country has seen, really can be sort of looked at in two phases. It was mentioned in that film, the early 1800s, and the experiments with the Quakers, who kind of thought solitary might be actually a more humane type of prison experience, and quickly discovered that it wasn't, and the practice was abandoned. And then the practice really fell out of use. There's actually an 1890 United States Supreme Court decision called In Re Medley that you would think would have put the final nail in the coffin of solitary confinement. And I'll just read to you an excerpt from this 1890 decision. It says, solitary confinement as a punishment for crime has a very interesting history of its own. The peculiarities of this system were the complete isolation of the prisoner from all human society and his confinement in a cell of considerable size, so arranged that he had no direct intercourse with or sight of any human being and no employment or instruction. Experience demonstrated that there were serious objections to solitary confinement. A number of the prisoners fell, even after a short confinement, into a semi-fatuous condition, from which it was next to impossible to arouse them, and others became violently insane. Others still committed suicide, while those who stood the ordeal better were not generally reformed, and in most cases did not recover sufficient mental activity to be of any subsequent service to the community. It is within the memory of many persons interested in prison discipline that some 30 or 40 years ago, the whole subject attracted the general public attention, and its main feature of solitary confinement was found to be too severe. So in 1890, the Supreme Court found solitary confinement too severe. But what happened was, in the 1980s, after the overall prison population had essentially remained stable from 1925 to 1975, suddenly in the 1980s, a different vision of prisons became predominant. No longer were prisons seen as places to rehabilitate people, rather they were seen as places to mete out very severe punishment. And in connection with mandatory sentences, the prison population in state and federal prisons doubled during the 80s and then doubled again during the 90s. So you had a quadrupling of the number of prisoners during the 80s and 90s, and yet the number of prisons remained the same. And so this idea of putting prisoners in solitary as a way to deal with the sheer numbers of prisons, and since prisons were no longer places where people would be rehabilitated or educated or given skills, many of them were just placed in these concrete boxes as a way to simply deal with them. As a result, from the 1980s to today, the number of people in solitary has continued to grow, as has the number of prisoners. And as you may know, the U.S. now has the highest rate of incarceration of any country in the world, and that has been the case for many decades, and something like 1% of the entire adult population of the United States is under some form of prison supervision. We have something in this country called the Eighth Amendment to our Constitution, and this is one of those provisions of the Bill of Rights which is not applied very vigorously when you look at how vigilant people are in protecting the right to firearms in the Second Amendment, and just fierce, rabid following of the right to bear arms. But you look at the Eighth Amendment, that's part of the Bill of Rights too, and that says we can't have cruel and unusual punishment of prisoners. And since solitary confinement has been around, there have been many court cases that have had the opportunity to consider solitary confinement. And it's not, I've read a lot of those decisions, and the practice continues today, and it really is generally not been found to constitute cruel and unusual punishment. And when you read these decisions, it really seems like the disconnect between the conditions that you read about and then the conclusions at the end of the case, because the decisions will recite the horrendous conditions of prisoners within the cells, of no contact with humans, no reading material, no ability to interact with even guards or other prisoners. And then at the end, the conclusion almost always is, well, we have to kind of defer to prison authorities in this matter. There have been a few decisions that have gone the other way, and those almost always deal with mentally ill people. There have been courts that have said mentally ill people cannot be held in solitary confinement, and in fact in New York State there is a piece of a law that says mentally ill people cannot be held in solitary confinement. But we still have in almost all state and federal prisons, and the majority of solitary confinement is state prisons. In New York, you would think it would not be the case, but in fact New York very enthusiastically uses the practice of solitary confinement, it varies over states. There are some states with almost no people in solitary. New York is one of the leaders. California is one of the leaders. There's a prison called Pelican Bay in Northern California that is one of the most notorious prisons. There's been litigation filed recently by the ACLU and hunger strikes of prisoners there over the last couple of years. There's a prison in Colorado called ADX that is a big federal prison. There's a film called Solitary Confinement that was put out by National Geographic a couple of years ago that you can see on Netflix. It's about an hour documentary, and they go into the cells and interview prisoners, and it's very powerful. So within the last few years, there's been more and more attention on this practice and more outrage on the part of the public, and it's not just the fact that we have so many people in prison, but it's the way we treat prisoners, and what does that say about us, and what does that say about our society. Last year, in 2011, the New York Bar Association put out a report that I wrote that I think copies are back there, that was one of the first bar associations to really criticize and draw attention to solitary confinement and really look at it as a human rights issue and look at it under international human rights standards. Under the Torture Convention, which the U.S. has signed, torture does not have to be physical. It can be mental. However, one of the reasons why lawsuits against solitary confinement are typically unsuccessful is because of a law passed by Congress in the early 90s called the Prison Litigation Reform Act that says, essentially, unless you have bumps and bruises, you cannot even get into the courtroom to get a judge to hear your case. So people in solitary confinement, the injuries are emotional and mental. You're not being beaten with a tire iron, so often those judges and prisons can use that to have cases thrown out, and prisoners don't really have a remedy against the practice. But I think that, you know, panels such as this one and discussions such as this one are kind of turning the tide a little bit, and we would hope that there would be some groundswell of outrage on the part of the population against this practice, because it really reflects, I think, poorly on our country, and just the sheer scope of it is something that I just think is unsustainable. So I think we'll maybe.
I've been remiss in not introducing each speaker, because it's all here on the back, but I'm going to do it anyway. I'm going to introduce David, and then I'm going to introduce Elaine. David is the author of Supermax Confinement in U.S. Prisons, has been serving on the Committee on International Human Rights of the Association of the Bar of the City of New York, and was also Chair Committee on African Affairs, Association of the Bar of the City of New York, Co-Chair ABA Section of International Law and Practice, as well as Managing Editor of the Human Rights Quarterly. Wow. Thank you.